Almost all social media business models are designed so that the platform will capture and engage you for as long as possible. They're places where we get to see pictures of our friends, our families, our kittens. But these platforms have also become hotbeds of hate speech, misinformation, and radicalization. One reason why misinformation and disinformation spread so quickly is because the algorithms track what you're watching and then they give you more of it. So if you're watching a video about an election result, that next video suggestion might be a video of someone just having a question about the results. But the longer you watch, the one after that might be about other elections that might have been rigged by a conspiracy. And then after that, you start going deep. A video that might be trying to convince you that there's a global conspiracy run by Jews. This is what we call the rabbit hole. You end up going deeper and deeper in what you watch until your whole content ecosystem gets occupied by these hate narratives that keep confirming each other. And this is how radicalization happens. So what are we doing about it? ADL's Protect and Repair plans promote a comprehensive set of actions that policymakers can take at the federal and state level to end the complicity of social media in facilitating hate and extremism. Because if one of us isn't safe, none of us are safe.
ADL's Council for Technology Policy and Advocacy. I'm thrilled to be here with you today at Click, Like, Share, Why Regulating Social Media Platforms is So Difficult. Though many of us used to think that social media was merely a place to share cat videos or family photo albums, over the last several years, we've seen just how influential social media can be in shaping conversations around elections, public health, and social justice. What happens when social media platforms play a significant role in fomenting hate, racism, and violence? How, if at all, can we hold them accountable? In this hour-long workshop, you'll learn a bit about the history of internet regulation, how platforms function today, how platform policies, product, and enforcement can fuel online discrimination and harm, and we'll end the session looking ahead to the future of internet regulation. Since this is not a typical panel discussion, I invite you to put questions in the chat as the program continues. We will do our best to incorporate them throughout the hour. A bit about our esteemed panelists before we get started. Spandi Singh is a policy analyst at New America's Open Technology Institute, where she leads and works on projects related to content moderation, disinformation, algorithmic accountability, government surveillance, and privacy. Singh is also currently a non-resident fellow at the Esya Center in New Delhi, a member of the World Economic Forum's network, expert network, and part of the 5th class of Google's Next Gen Policy Leaders program. Bertram Lee is counsel for media and tech at the Leadership Conference on Civil and Human Rights, where he works to advance the interests of marginalized communities in technology and media policy. His portfolio includes broadband access, media diversity, facial recognition, law enforcement surveillance technologies, Section 230 of the Communications Decency Act, algorithmic bias, artificial intelligence, content moderation, and platform accountability. Previously, Bertram worked as policy counsel at Public Knowledge, and prior to joining Public Knowledge, he served as counsel at the U.S. House Committee for Education and Labor under Chairman Robert C. Scott. Thank you to our exceptional panelists for being here. I'm going to talk to you a little bit today about some questions that we have. And hopefully my presentation will come up so that I can show you all a little bit about some of the things we think about when it comes to how and why regulating platforms on social media is so difficult. Can we really say whatever we want online? Why aren't social media companies responsible for what users say on their platforms, even when they know what's going on? These are some common questions that come up when discussing platform accountability. But before getting into what we can do, which we will talk about today, I want to focus on 2 core laws that have deeply impacted internet regulation: Section 230 of the Communications Decency Act and the First Amendment, which I'm sure most of you have heard of. It's important to know how we got here to this environment, this internet ecosystem. But we have to go back to 1990 to do so, the dawn of the internet age. 1996, there was profound optimism about the potential for the World Wide Web. This quote is a good example of how people felt regarding the opportunities to come. This is from the Declaration of the Independence of Cyberspace. And though I don't ordinarily read quotes during presentations, I think this one's worth reading. So John Perry Barlow, who was one of the founders of the Electronic Frontier Foundation, wrote this essay, and it got a lot of publicity and support in the internet and technology community at the time. We are creating a world that all may enter without privilege or prejudice accorded by race, economic power, military force, or station of birth. We will create a civilization of the mind in cyberspace. May it be more humane and fair than the world your governments have made before. Well, unfortunately, I think Barlow got it wrong. And in fact, when he was reflecting on this essay in 2004, he said something along the lines of, "We all get older and smarter." And what I mean by that is that we know it's far from the case that people are treated equitably online. In fact, according to ADL research, 1 in 3 individuals who experience harassment online attribute it to their identity. So we are being impacted based on what we look like, how we pray, and who we love when entering physical spaces and online spaces. But that's not what people were thinking about in 1996. They were thinking about the potential and the opportunity and what's to come. And that motivated the Communications Decency Act. Now, this act was actually an attempt to regulate pornographic content on the internet as it was emerging, and most of the Communications Decency Act was actually overturned. But Section 230 remained. This is a short but highly influential law. As it says here, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. What that means is that platforms, websites, other interactive computer services had immunity from liability for the content that third parties or users posted on their platforms. This law, Section 230, is often called the 26 words that created the internet. That is coined from cybersecurity professor John Kossoff. And at its core, again, it means that it's incredibly difficult to hold a platform accountable for what content proliferates on that platform if it's user generated, if it's not generated by the platform or company or website itself. Section 230 has been interpreted really broadly since 1997, providing that umbrella of protection. And it's been both applauded and criticized. It's been applauded as the linchpin for an explosion of innovation, for the way that the technology sector looks today, for the ability for social media platforms, other websites, financial tech websites, anything that has user-generated content associated with it. It's been considered a really big tool to be able to innovate and create that, because the fear of liability for what users may or may not do or say on a platform is essentially taken away. At the same time, Section 230 has been criticized because it's also been seen by some as a tool for platforms to really focus on their business model, on engaging users, as opposed to putting top priority moderating or managing content when it comes to hate or violence or imminent incitement. The fact that platforms may care and manage this content but don't need to put that as a priority because they are not going to be ultimately held accountable for what is or isn't said on the platform. Lastly, Section 230 has really chilled guidance from the courts about our internet ecosystem. So while there are some laws regarding what is and isn't lawful online, there haven't been too many cases that have moved forward to interpret what those laws mean. And that's because it's really hard to sue platforms and to get past a motion to dismiss and get into evidence and other judgments and motions that could provide us with a little viewpoint into interpretation from the courts. So that's a little bit about Section 230. My co-panelists are going to talk about it as well. But there's another important question we haven't addressed. What about free speech? So ultimately, the First Amendment is incredibly powerful and provides us with a lot of protection. But a common question is, doesn't that play a huge role in what we can say or not on social media? And the answer is yes and no. I have the language up here just as a review. Congress is the one that is prohibited from abridging free speech. And that means while the government has to adhere to free speech principles, private companies like social media platforms can create their own rules and guidelines. So if they want to outlaw hate speech, whether or not it's protected by the First Amendment, they can do so. And they have done so. Most platforms and other websites will have community guidelines explaining the rules of what is or isn't allowed to be posted, and then they're welcome to manage that content. In fact, Section 230 was enacted to encourage some of that content management. So yes, you can say a lot of what you want online, but if you're entering into specific spaces, those spaces may or may not have to adhere to the First Amendment, like social media platforms. Additionally, when thinking about the First Amendment and free speech online, it's important to recognize that there is a lot of unprotected speech that goes on online and offline. So not everything we say is necessarily protected by the First Amendment, whether it's solicitation, obscenity, harassment, or defamation, whether they're civilly or criminally unlawful. We can't just say anything. People often use the example, you can't yell fire in a movie theater. You can't incite imminent violence. These are things to also think about when we say things like, well, I can say whatever I want online, which not everybody does, but some people think is true. Lastly, I want to talk about conduct. Because we live so much of our lives online, more than speech happens. There's activity and behavior going on, and just because it's virtual doesn't mean it's real. According to ADL's 2021 Online Hate and Harassment Survey, 27% experienced severe online harassment. That would be stalking, sustained harassment, sexual harassment, or things like doxing, which is putting someone's personal information online with the intent that it be used for an unlawful purpose, or swatting, which is calling in a false emergency to draw a robust emergency response to someone else's dwelling, which has actually ended in fatality before. This is more than speech. And so when we think about what's being said or done online, it's important to think about both content and conduct. Finally, where is all of this taking place? Well, unfortunately, hate, harassment, the normalization of extremism and racism, it's not only happening in the dark corners of the internet. It's also happening on major social media platforms. Our survey again said that of individuals who were harassed online, 3/4 attributed at least some harassment to Facebook. So they were harassed at least in part on Facebook, nearly a quarter on Instagram and Twitter, and more than 1 in 5 on YouTube. This is happening on highly resourced, highly profitable, major social media platforms. So I think we're almost ready to talk about how social media exists today and what type of environment we're in and its influence. But to take a step back one more time, I just want us to look at the continuum here. What's happened since 1996, since the core of internet regulation was enacted and very limited measures of reform have come into place? Well, in 1996, 40 million people worldwide had internet access. Today, over 4.6 billion people use the internet. In 1996, social media didn't exist. The iPhone was more than a decade away, and Mark Zuckerberg, founder of Facebook, was 11 years old. As we see in 2004, Facebook was founded, 2005, YouTube, 2006, Twitter, and 2016, TikTok was founded. So much has changed since 2021, and it's really important that when thinking about how best to reform and regulate our internet, we consider our world today in addition to the foundations. As I've talked about a little bit, there's definitely a lot of issues with the way that social media platforms are currently run and regulated. We know that online harassment is rampant and too often identity-based. We've seen disinformation and its power related to electoral, public health, and other information, and the fact that it has the power to undermine our democratic systems. Business models tend to incentivize this, And I know some of my panelists will talk about that today. And additionally, again, without updated regulation, self-regulation is not enough. There's outsized power for platforms, but limited liability. But we know how important a free and open internet is as well. We have to look at both sides of the coin, whether it's organizing or innovation, or over the last year and a half, or almost two, in light of the COVID-19 pandemic, the ability to engage in education, worship, family socialization, and so much more using digital affordances and our internet is incredibly important. So how can we responsibly regulate and reform our internet systems? That is the question. But it's so important to think about the foundation and where we are today in doing that. I'm almost going to turn this presentation over to Spandy Singh. But first, if you are attending for CLE credit, please note your first verification code in the Q&A pane. As a reminder, the Q&A pane can be found to the right of your screen on computers and tablets, or to the bottom of your screen on the phone. I'll hold there and let Spandy take it away.
Thanks, Lauren. Hi, everyone. My name is Spandy Singh. So I'm briefly going to walk you through some of the technologies and policies that guide how internet platforms moderate and curate the content we see online. And I think it's really important to have a foundational understanding of these processes because this enables you to identify and understand potential harms that can result from these systems. And they also let you think more analytically about how to best regulate these kinds of services. Just making sure that clicker works. Okay. So over the past few years, the field of content moderation and curation has rapidly evolved. And I'm going to briefly walk you through some of the mechanisms that platforms use to shape and curate the content we see online. Many of these processes rely on artificial intelligence and machine learning tools. So the first is content moderation. Content moderation typically takes place when a platform determines that a piece of content or account violates its policies. And when this happens, the service can remove the content or suspend the account of the user who posted the content. Platforms increasingly rely on AI and ML to fuel their content moderation operations. So for example, they can use these tools to detect violating content. They can use it to send content that has been flagged or detected to a human who will then determine whether it should be removed. And in some cases, platforms will also use AI and ML tools to sort of independently assess and remove content that it deems violating without keeping a human in the loop. The second category of approaches is downranking. So this is most commonly used when you have a social media newsfeed. So for example, if you open your Instagram newsfeed, all of the content that you see has been algorithmically sorted, ranked, and presented to you by an algorithm. And the algorithm uses a range of metrics to determine whether a piece of content is relevant to you. So for example, let's say we're looking at my Instagram feed. I consume a lot of French Bulldog content. And so the algorithm is going to know that this kind of content is relevant to me, and it's going to rank similar content in the future higher up in the newsfeed. Alternatively, if there were videos of kittens, it would say, this person's not really a cat person. So it would rank that kind of content lower in the newsfeed compared to the French Bulldog content. And platforms generally use, all of the content in the newsfeed is ranked in some way, but platforms generally use algorithmic ranking and downranking to moderate and curate content when it comes to things like disinformation and low quality content like clickbait. So for example, on Facebook, the company will downrank content that it has sent to its third-party fact checkers, and the fact checkers have determined that it's misleading. So when they downrank it, that content appears lower in a user's Facebook newsfeed, and therefore they call it reducing the distribution of that content because it's lower in the feed, so it's getting less views. The third category is recommender systems. So many platforms use recommendation engines to suggest content to users. So for example, on Amazon, the service will collect data about your purchase history, your browsing history, and then they may make recommendations on items that you would be interested in purchasing. Similarly, on YouTube, the service will collect data on the kinds of videos you've watched before and make suggestions on the kinds of videos that you may be interested in watching next. And as the introductory video explained, this can have many benefits. If you're trying to find more similar types of content, that's great. But in certain situations, it has resulted in the amplification of extremist content, conspiracy theories, misinformation, and it kind of pushes users down a rabbit hole that it's very hard for them to get out of because the algorithm is assuming that all of this content is relevant to the user. In the context of moderation and curation, and sort of in response to a lot of really great research that's been done to investigate how this rabbit hole effect happens, some platforms have introduced changes where they can intervene in recommendations to prevent certain types of content from being suggested to a user. And we've most recently seen this in the context of COVID-19 misinformation and election disinformation. The fourth category is advertising. So in addition to enabling users to share organic content, many social media platforms also allow users to, advertisers to pay to advertise ads. So companies have specific processes for reviewing and delivering these ads, and many of them rely on AI and ML, and I'm sure Bert will talk about this a little bit later, but many of the concerns that have arisen in the advertising context is when advertisers are permitted to deliver ads in a discriminatory manner, particularly when it comes to things like housing, education, credit, and so on. And then lastly, many platforms also use a myriad of other mechanisms to moderate and curate content. So for example, some platforms may label content to indicate that it's been fact-checked or to indicate that it's graphic. Other services may quarantine content. This is, or communities, this is more popular on Reddit. When the company determines that a certain community has violated the rules, they'll quarantine them so that the content that they post doesn't get amplified for a certain period of time. So why should we care? We've talked about the different kinds of mechanisms that platforms use, but why does it matter that they use these different approaches and the fact that they use AI and ML? Really, at the end of the day, these services determine what content you see, when you see it, and where you see it. And we rely on these services to obtain information about the world around us every day. And so really, these platforms are determining what information you see, and they're determining how you see the world around you. If you opened your Facebook feed tomorrow and all you saw was COVID-19 misinformation, you would have a very specific opinion and viewpoint on the pandemic, on vaccines, on masks, and so on. And similarly, during election cycles, or even just generally, if you have a newsfeed that's very polarized or has what many researchers call a filter bubble or echo chamber, you're going to see critical political issues in a certain way and not have a very well-rounded approach on things. And the main reason that these platforms are so influential is because of these algorithmic tools that they use. These systems can be beneficial to platforms for many reasons, and I do want to just quickly walk through these because I think it's important to understand both sides of the coin. So these systems may allow a platform to detect, remove, and moderate content at scale, especially, and this is really important when it comes to harmful content. And it's important to contextualize this. So I'm just going to throw out a stat. As of February 2020, over 500 hours of video were uploaded to YouTube every minute. So that means in 1 hour, around 30,000 hours of new content were uploaded to the service. And so using algorithmic tools allows platforms to sort through this content, remove harmful content at scale, and determine who should be seeing what. At times, AI and ML systems can also be used to sort of mitigate human bias in the moderation process. However, these systems are definitely not perfect, and that's where a lot of the concerns come about because platforms are increasingly relying on them. So there are generally like 5 key reasons that these these tools are very limited. The first is that these systems are often unable to understand context and nuance. So for example, let's say that the word apple is a derogatory slang term in a certain community or in a certain language, but it isn't in the English language or in the United States. An algorithmic system is not going to be able to understand the nuances in speech, particularly when it comes to slang, which is constantly developing and changing. And so it's either going to, over moderate content or under moderate content. It's not going to be very effective at sort of moderating the speech at hand. And a really good example of this also, which shows just how fluid speech is we've seen many extremist groups adopt sort of hand signs to indicate harmful or violent sort of symbols or messaging. And many of these hand signs are sort of innocuous around the world. And you would really need to have a contextual understanding of who these people are and how they operate, what their beliefs are, in order to understand that it's actually violent and hateful content. Similarly, the second limitation for platforms is that sorry, could you click next, please? I don't think the clicker is working. Thank you. So the second challenge of these systems is that they have difficulty identifying and assessing content that does not have clear definition. So things like misinformation and disinformation, things like hate speech. It's often difficult to draw a very clear line between what's actually harmful and violent content, what's satire, and what's just innocuous content. And these are very difficult lines for a human to draw, and so it's even more difficult for an automated tool to draw these lines without clear parameters. Could you go to the next, please? Thank you. The third category is data set bias. So the automated tools that platforms use are really only as good as the data sets that they are based on. So if you are trying to create a hate speech classifier, for example, but you only train it on hate speech examples in Washington, D.C., for example, it's not going to be a very effective classifier at moderating hate speech when it comes to hate speech in Italy, in Indonesia, in India. And so the data set that you choose really shapes the breadth and depth of how effectively that system works. Could you go to the next one, please? Thank you. The fourth category is creator bias. So creators, the people who are selecting the data sets and who are developing the tools have a significant amount of influence over how these tools perform. So if I've never heard of a certain extremist group, for example, but I'm creating a classifier that's supposed to detect extremist content, because I've never heard of them, I'm not going to include any examples of that in the training data. And so that classifier that I developed is not going to be very effective at moderating that kind of content. And next, please. And then lastly, many of these systems operate in a black box. And what this means is generally we have some limited understanding of what the inputs into these systems are and the outputs, but we don't have a lot of insight into how they're actually making these decisions. And where this becomes really problematic is when these systems generate outputs that are different from what was intended, especially in cases where the outputs are discriminatory or harmful. And this fundamental lack of transparency that we have around how these tools operate makes it difficult to make nuanced recommendations on how these systems should be changed. So, because of the harms that can result from these systems, civil society organizations have been pushing companies to provide 4 key things. The first is notice to impacted users, so they can understand why their content and accounts were impacted. The second is appeals, so that impacted users understand who believe that the decision was unfair, that their content shouldn't have been removed or otherwise moderated, so that they have access to due process, so remedy and redress, and especially a timely due process. The third category is keeping humans in the loop. So although humans have bias, it is pretty critical to keep a human in the loop so they can provide oversight on these systems. But I think one really important point to drive home is that If you have a bad algorithmic system, if it's ineffective, if it's inaccurate, no amount of human review is going to correct for that. So you still need to ensure that the tools that are being developed are robust and effective. And then lastly, civil society, including OTI particularly, have been pushing platforms to provide more transparency around three key things. The first is the policies that guide when they moderate or curate content. So if a platform is going to say, we do a lot to moderate disinformation, we downrank it on our news feeds. We want to know what kind of disinformation are you downranking? When are these policies applied? The second category is around how these tools are trained and developed. And arguably, I would say that this is the area of transparency where we have the least information. And then the third is we particularly want transparency around the impact of these tools. So many platforms say, we're doing really great at moderating hate speech. Our classifiers are great at tackling disinformation, but we want concrete data that demonstrates what the strengths and limitations of these tools are, because this helps us make more nuanced recommendations, and it also informs more responsible regulation. Next slide, please. So what makes content management so difficult, and why haven't platforms gotten it right yet? As we've discussed, next slide, please. As we've discussed, the AI and ML systems these companies use are not perfect, and they will make mistakes. Next, please. And another one, thank you. Additionally, if companies are not providing adequate transparency, advocates and lawmakers are limited in their ability to make responsive recommendations. And then third, scale. Given the vast amount of content on each platform, realistically, the company is not going to be able to catch everything. And just to tie that all up, these are all very important reasons, but I think in the current day and age, the most challenging issue to pushing platforms to do better and to regulating platforms is their business models. And Lauren talked a little bit about this as well. But platform business models have a very strong influence over company priorities. So, recent reporting has confirmed what many advocates have been saying for some time, which is that platforms like Facebook design their AI systems to prioritize amplification of engaging content, even if that content is harmful in nature. So what that means is, the more content you're consuming and the more engaged you are in the service, the more time you're spending on the service. Next one, please. Thank you. And one more. And the more time you're spending on the service, the more platforms can target you with ads. And targeted advertising is a central component to the business models of many social media platforms. So by designing the algorithms to promote engaging content, these platforms are actually driving their bottom line. And that's where it becomes very muddy, because addressing things like disinformation, hate speech, and extremism in a meaningful way would directly impact these platforms' revenue models. Slide, please. So it's become more apparent that social media platforms and the algorithms that they use are capable of generating harmful and discriminatory outcomes. And so many lawmakers around the world have been thinking through how they can effectively rein in these companies. And as of now, there are many different legislative proposals, but they generally fall into 6 categories. So the first one is many lawmakers have been thinking about how they can expand privacy controls and user protections so that users have more rights when they're engaging with algorithmic systems. And I should say this is probably the most important next step that lawmakers in the United States can take, because without effective privacy legislation, you can't meaningfully rein in how AI systems work. Privacy is like the foundation of that kind of regulation. Second, many lawmakers have been thinking about how they can obtain greater transparency from platforms around the policies, the impact, and the technologies that drive many of their content curation mechanisms. Third, many lawmakers are thinking about establishing requirements for internal or independent evaluation oversight. So this includes things like independent audits and assessments. The fourth category of legislation that we've particularly seen in the United States more than in other countries is there have been many efforts and proposals to reform or amend or repeal Section 230 and change the liability protections that platforms have right now. The fifth category is we've seen some lawmakers in the US, but more so in the EU, think about how they can prohibit certain types of harmful algorithms, which they have determined pose too high of a risk to society. And then the last category is using existing legal frameworks. So, for example, in the United States, some lawmakers have been thinking about how they can use civil rights laws to take effective action against platforms whose algorithms generate discriminatory results. And just to wrap it up, I'm sure this is something we're going to continue talking about after Bert is done. But why is it so hard to regulate platforms right now? What are the existing challenges that exist? The First Amendment and the Section 230 definitely create specific US-specific nuances, and so any laws, of course, have to be compatible with these. The second is, feel free to just go through the entire slide. Right now, we really lack consensus and multi-stakeholder consensus around the next steps that we need to take. So we have a lot of lawmakers and advocates, for example, saying that we need meaningful transparency from platforms, but we haven't reached consensus around what actual data points we want from platforms and what meaningful here is constituted by. Similarly, we don't have clear definitions on things like algorithmic systems or high-risk AI. And so it's very difficult to regulate algorithmic systems if you don't even have a consensus-based definition on what we're trying to regulate. Similarly, there's a big push for platforms to submit to independent audits, assessments, and so on, but there are absolutely no consensus-based frameworks that determine and answer, who is conducting these audits, what are we auditing, when is this audit taking place, how often, and so on. And similarly, there are very few resources to support these kind of independent evaluations from taking place. And like I mentioned on the previous slide, without privacy legislation, it's going to be incredibly challenging to create any sort of meaningful regulation related to algorithmic systems. Thank you.
Thank you, Lauren. And Spandy's presentation was a perfect encapsulation of some of the issues that I'm going to talk about today. But first, I want to introduce kind of the organization that I work for. The Leadership Conference on Civil and Human Rights is a coalition of over 200 civil and human rights organizations, including the ADL, who have been involved in all sorts of civil rights laws from the inception of these laws, from the early 50s until now. Every single major civil rights law has either in some way, shape, or form gone through the Leadership Conference on Civil and Human Rights. And that's where I think we're going to start this conversation. And I also want to add, for further context, I'm going to use the term marginalized communities a lot. Marginalized communities is best defined as folks who fall into protected classes, whether it's age under the Age Discrimination and Employment Act, whether one has a disability under the ADA, whether one is of a different ethnicity, race, gender, or sexual orientation. That's going to be a coverall term that I'm going to be using a lot, so I didn't want people to get confused with that in the beginning. Definitions are really important. And so I want to start first, and the history of the Leadership Conference is really important because when traditional civil rights laws were developed, there was no concept for the current technological revolution we have right now. These laws were developed in their time, right, where more broadly, protected opportunities, as defined by Pauline Kim, which is another term that I'm going to use, describe a range of protected activities for civil rights law, such as access to housing, credit, employment, and education. And these issues were so important at the time because these were the most segregated and where discrimination was happening at such a broad scale. And there are other civil rights laws that apply to law enforcement and voting protections as well, right? And so where discrimination particularly manifests itself on platforms, it comes not only to how those tools are used, but how they're developed. And so when Spandy was talking about AI and machine learning and also data sets, what we have is a history of these not only tools and how they're used, right? Whether we're talking about what happened with the credit crisis in 2008, 2009, about how many homes of members of marginalized communities, particularly Black communities, were hurt during that crisis, or whether we're talking about ways in which housing has been given, or whether how employment decisions are made. Disproportionately, those decisions impacted marginalized communities way more than it did white communities. And so when we're talking about how these platforms enact themselves and how platforms are disproportionately hurting marginalized communities, we have to think about the history of these tools as well, and to think about how the tools are being used. So whether it's the data set, whether it's the AI and machine learning itself, how it's used, and what the best connectors or most easy connectors for it to make are, we have to think about those things as they move forward. And really, one great way of doing that is describing the difference between intentional discrimination and disparate impact. In civil rights law, there are two ways to go about finding discrimination. Intentional discrimination, which is kind of self-evident, but it's great to always have definitions with these things, where it's at least in part a decision is made by the actual perceived race, color, national origin of the alleged victim. Right. Whereas disparate impact is that a practice by a covered entity adversely affects one group of people of a protected characteristic, even if those rules are on their face neutral. We have to define those things and especially when we're talking about platforms, because platforms are engaged in any number of activities. Right? Facebook has a marketplace, it has jobs, there is a housing space in there as well, right? Google has Google Jobs as well. There are travel accommodations that you can make on any of these sites, which are protected by Title VI and the public accommodations concept, right? And so we don't really know how deep the proverbial rabbit hole goes with respect to how discrimination works on these platforms that we use every day. We do not know the impact that these platforms are having on marginalized communities right now. And moreover, we don't have the proverbial understanding of how and where discrimination enters into the stack for us to be able to make really the best informed decisions. But we do know things need to change, right? And so with the limited amount of research that we do have, particularly in hiring and search, what we do know is that the impact that it has on these communities can be profound. Right? Think of the Upturn report and what the Brookings study has found, right? Advertisers and other folks are able to target marginalized communities with almost deadly precision, right? And we can see that discrimination is occurring and across the spectrum, not only to BIPOC or people of color, but to the LGBTQ plus community, to religious minorities, to women, right, as well. And so content moderation discrimination is important from a civil rights perspective because we have seen platforms target marginalized communities, as was highlighted in the Senate Intelligence Report in 2016 election, where Black people specifically were targeted, and also in 2020, where Spanish disinformation was pervasive throughout the 2020 election, right? And so the concerns with the social media monitoring, concerns with discrimination happen along, I think, 4 different axes, right? One is advertising, as Spandy highlighted, right? The second is data collection. What do these platforms know about us, and what is the history of the data set that they're using, right? If we're using a law enforcement data set, we know how that's going to move. If you're using an employment data set, there are likely discriminatory ways in which employment has happened toward these marginalized communities in the past. The third would be content moderation. Who gets heard and how much? How much is their voice amplified and why, right? And then lastly, the actions of the platforms themselves, their artificial intelligence and machine learning platforms. And moreover, what are they attempting to do? What problem are they trying to solve? And is there a better way to solve that problem? That does not necessarily mean that you are discriminating on it, on its face, right? And so the Leadership Conference thinks about these things within broad buckets. We have the civil rights principles. A number of groups have signed on to them, and they are incredibly important. The first is ending high-tech profiling. Surveillance technologies are empowering governments and companies to collect and analyze vast amounts of information about people. And too often these tools are deployed without proper safeguard or are themselves biased, right? Second is ensuring justice in automated decisions, right? Statistical technologies, including machine learning, are informing important decisions in areas such as employment, health, education, lending, housing, immigration, and the criminal legal system. And these decision-making technologies too often replicate and amplify patterns of discrimination in society, as I said earlier. The third would be preserving constitutional principles. Enforcement of the constitutional principles such as equal protection and due process must keep pace with how not only the government uses technology, but also how industry uses these technologies. And how and why industry sells or uses these technologies with government must comply with these constitutional principles as well. And then I'll say fourth, ensuring that technology serves people historically subject to discrimination. Technology should not merely avoid harm, but actively make people's lives better. Governments and companies who design and deploy technology should strive to mitigate social inequities, not make them worse. Defining responsible use of personal information and enhancing individual rights, corporations have a pervasive access to people's personal data, which can lead to discriminatory, predatory, and unsafe practices. We need to mitigate those practices in order to create a more just and fair society. And then lastly, making these systems more transparent and accountable, as Spandy highlighted. Governments and corporations must provide people with clear, concise, and easily accessible information on what data they collect and how it is used. This is critical not only from the perspective of how these platforms engage in their business model, but also the kinds of remedies that we as a society and as a civil rights community would like to be seen with respect to how these tools are used with these communities. And so, not to belabor the point, because I know we do want to get to Q&A, but there are some key takeaways that I think we should all really be thinking about, right? Well, one, there is not enough transparency within the context of our current digital ecosystem. We do not know how data brokers are getting their information, or how the platforms are using that information in order to target or not target particular communities. Secondly, there is no current way to verify the platforms are or are not engaging in discrimination, which is problematic. But the research that is being shown right now across not only from where the Facebook whistleblower is coming from, but also independent research from Brookings and Upturn and any number of other organizations and institutions is showing that discrimination is broadly pervasive throughout the digital ecosystem, and we need to verify what's going on and understand those levels of discrimination. And lastly, we need to ensure that platforms are engaged, and the government makes sure that platforms are engaged in active steps to reduce discrimination and allow more people access to protected opportunities. Because if we don't, that is going to not only further the inequality that we're seeing in society, but also potentially make it even worse than it currently is right now.
Now, thank you both for really laying out the problem, laying out the impact. I want to look ahead to, what is possible. And Bert, you mentioned the Facebook whistleblower leaked documents. And just to level set for a minute, in late September, a Facebook whistleblower came forward with tens of thousands of pages of internal documents showing a lot about Facebook's knowledge for its role in things like motivating the insurrection and causing harm to users and discriminatory impact. How have these revelations changed the calculus of the conversation around internet reform? That'll be to both of you, but whoever wants to start first.
I think, I mentioned this during the slides, I think the Facebook whistleblower's revelations really confirmed and provided evidence to something to many of the points that advocates have been saying for years, and companies have continuously pushed back against and said, no, this isn't true. Our internal research says different. Many of the documents that were leaked proved otherwise, and I'm hoping that can create enough momentum and provides enough evidence for there to be responsible regulation. I also think one of the most important things the Facebook whistleblower showed was just how much of an inequity there is when it comes to content moderation and keeping users safe online between users in the United States, in the European Union, in more Western countries, and users living in other parts of the world, like in the global South, or who are not English speakers. And I think that is probably something that platforms will have to reckon with or without regulation, because it's something, again, that many people have been saying for a long time, but platforms have been selectively releasing numbers that paint a different picture.
Thanks, Manny. And that goes to transparency as well. Bert, over to you.
No, I was just about to agree with Spandy and highlight just a few things that I took from that. One, the version of Facebook we have is the best version of Facebook, which should kind of, I think, scare everybody. But also, I think that the platforms, and I think civil society has highlighted this, particularly the civil rights community, with Facebook's audit, right? The problems that Facebook and really more broadly kind of like the social media platforms themselves face are much more dangerous and much bigger than I think they even realize. And the potentiality of harm is so much broader. And so understanding that and really getting a grip to that and really being at least humble enough to think through what solutions would look like, and being open to how people want to be regulated and how people want their platforms to be engaged with is something that I think members of Congress are taking seriously, but I hope the platforms are as well.
Thanks, Bert. And just to add in there a little bit, I think I agree certainly with both of you. And Spandy, how you opened, the answer to this is something that we certainly at ADL have been saying for a long time, and I know your organizations as well. This is confirming a lot of what we already knew and certainly suspected, especially when it comes to hate speech for ADL and our tracking of online hate and harassment. According to the leaked documents, Facebook only takes down 3 to 5% of all hate speech that proliferates the platform, only takes down 0.6% of incitement to violence content that proliferates. And so that's where we get the need for a lot of different regulation measures, but certainly transparency, which I know we've all touched on, and being able to increase the trust and understanding of our systems, because certainly for social media, it's very fractured. So I want to follow up a little bit more with a couple questions from the audience, and then I'll turn to the real future, which one was, how do we get social media consumers to better understand the products that they're using and be aware of the underlying risks?
I would say that I think people are starting to realize what their use of social media will eventually become and is doing to broader society. But also, there's a famous quote that one cannot free themselves using the tools of the oppressor, right? But unfortunately, I think that's where we find ourselves in a lot of ways. We are going to have to use social media to highlight the harms of social media, because that is one of the fastest ways to engage with people. And, it's a real interesting choice in that way. But I think more broadly, I think for people to better understand the impact of social media, I would challenge people to do this. I would challenge people to go a week without touching any social media and see what changes in their life and just what impact that has. I think that really, for the folks who have done it, I think it's been a clarifying experience as to what they really value and who they really value in those ways. And so it's going to have to go down to the individual, unfortunately, because no matter what legislation comes down off of Congress, they're not going to ban Facebook. They're not going to ban Twitter. They're not going to ban Google. Those platforms make too much money for too many people, unfortunately. But as an individual, you can make responsible choices with respect to those platforms.
Yeah, and I would add, it's difficult, but do your own research. I can't tell you how many conversations I've had with people who are saying things like, why does privacy even matter? Does it really matter that they have all my data? And I feel like once you do your own research, and all of our organizations have put out work on this, trying to explain what the harms are and what changes can be made. Once you sort of develop that understanding and that basic sort of digital literacy of what's happening with your data, what's happening when you consent to using a social media platform, and so on, then you can sort of begin to take more responsive actions. But if you're not really aware of how these platforms are shaping your life and using you as a product, then you're not really going to be able to push back and exercise more agency.
I absolutely agree with both of you. And I'll add one more piece to the puzzle, because we know it's a complicated puzzle. But another thing that people can do to be more empowered and understand a product like social media platforms and be aware of the risks is to know how they are contributing to things like algorithmic amplification. So, we can take the election, and whether or not someone posts or likes or shares content because they agree with it or because they're outraged. Either way, it contributes to the continued spread of that information. So if we understand how platform content works to engage people, to sell more advertisements, that ecosystem, and how we contribute, should we like something? Should we share something? Why is it better to share something through private means or in person versus on social media? what's our ultimate goal with engaging in the space. I think a combination of all the things that were mentioned, Bert mentioned taking some time away, understanding what the value proposition is of the platform. Spandy mentioned better understanding the issues. Google, though there are certainly issues, is very powerful to bring a lot of this, and all of our organizations have them. And then, of course, knowing your role. How are you contributing, even if you might not think you are? All right, so I want to ask another question to you, which is, this is a big problem. Are you optimistic at all about the future of our internet systems of reform? And if so, why?
Spandy, I'm waiting for you at this point.
Okay.
But I'll go ahead.
I'm going to say yes.
Right? A little.
There's some, it's a yes and no. I'm honestly more optimistic when it comes to legislation in the EU. The proposals that lawmakers have put forth in the EU aren't perfect, but the proposals reflect a lot more analysis and understanding of the issues at hand than the proposals I've seen in the United States. And so I'm optimistic that, the EU might set the tone for regulation in the US, and the US might follow suit. But I think in order for me to be a little more optimistic on the US front, I would have to see policymakers here go a little further than just saying we want to regulate, and demonstrate that they are actually investing the resources and getting staff who understand, the nitty-gritty of these policy issues and the technical issues. Because so far, I think a lot of the proposals are lacking, frankly.
And just to add quickly, I think my concern is not of the kind of technical variety, but more of the kind of civil rights variety. And whether civil rights laws are going to be thought of and considered in the various legislative proposals that have been offered. And I'm optimistic that they are. To what extent, though, is a different story, right? And so that needs to be kind of continued. That needs to be a continuing conversation on those fronts. But with respect to where I think we're going, I think there's a chance that we could turn a better corner. I just hope that, members of Congress, and I think the agencies that regulate these platforms even in some fashion, or in some form or fashion, I think whether they follow through with that is going to be that's going to be a further determination. We shall see.
I think you're right. We're in that moment where tens of thousands of documents are confirming things we've known for a while, where people are trying to get smarter, engage in hearings, hire more technical staff, but even more needs to be done. So we're close, but we're not quite at the home stretch. But there are conversations like these, and I know that they're happening across the board, and also hopefully with law and policymakers, they are. Once we have an increased education about the landscape, about the ecosystem, not just how it started, not just 1996, but how it impacts our lives today. Thinking about civil rights laws, thinking about anti-discrimination practices, thinking about technical expertise, understanding algorithmic amplification, understanding machine learning or artificial intelligence and that impact. I think we're getting closer to having that, that full picture, but we're not quite there. So I'm also cautiously optimistic that we'll be moving forward. Well, I think that is all the time we have today. So I really want to thank Bertram and Spandy for being here, for sharing your insights, and really, truly for continuing the conversation and working in coalition together.